Big news breaking this afternoon out of Kenosha, Wisconsin. A jury cleared Kyle Rittenhouse of all 5 charges in a shooting that took place during a night of protests and violence in the summer of 2020. The jury returned its verdict after almost 3.5 days of deliberation, about 26 hours worth. 18-year-old Rittenhouse could have faced life in prison if he was found guilty of the most serious charge against him. So let's bring in Ion Meyn. He is a professor at University of Wisconsin Law School in Madison to give us some instant analysis on the verdict. Professor Meyn, welcome to Quicktake. I want to start obviously with whether this acquittal was surprising to you or whether it was something you anticipated legally.
It's not unexpected and is troubling, and it's certainly within the realm of what we could expect legally.
Why is that?
Because what the self-defense instruction is it gives a lot of discretion to the jury. It's really a community standard. It helps reflect where we are about what we think is reasonable when it comes to using deadly force to defend ourselves. And so there's no guidance in the law as to what that is, what that point of reasonableness is. It really is a community decision. And so it certainly can reflect who we are at the moment in terms of how our encounters go and what we can expect from those encounters in terms of how much discretion people have to use deadly force against others.
If that's the case, tell us a little bit about Kenosha. Kenosha is not the same as Madison. What kind of community is Kenosha that would interpret self-defense this specific way?
That's a really interesting question, and you're right that the juries in different places might have a different approach, right, to the same question of reasonableness. And just in terms of a general comment, quickly get to your, but this is a 17-year-old when he did it, so I think any kind of jury is going to take that into consideration, that the fact of the matter that this is a 17-year-old, and that would be different than if this is a 30-year-old male. To your question, Kenosha is a more conservative kind of environment than Madison is. So to your point, it is a reflection of the community standard, and this could certainly have gone a different way if this was in a different jurisdiction like Madison, which is in Dane County and is more liberal.
So if I'm hearing you correctly, you're basically saying that what self-defense means pretty much depends on who the jury is and where this case is taking place, where the trial is occurring.
I think that's the case, and that's certainly the case with other matters too when you're talking about what is reasonable. But I think it also reflects parts of the national kind of consensus about what use of force is in terms of deadly force, and it might be different, as you're suggesting, in California than it might be in Texas.
By the way, I just want to point out that we're looking at live pictures of the courthouse in Kenosha. This is right outside the courthouse. There are some protesters there. They've been there since the beginning, since the jury began deliberations. There is some police presence, but as far as I've checked, there hasn't been any kind of physical conflict that has been reported thus far. But we'll keep you posted on any developments there. Again, live photos of the courthouse in Kenosha, Wisconsin. Professor, given that he was acquitted of all charges, why do you think this particular case was so divisive? I mean, it was something that everyone in the nation talked about. Hedge fund billionaires, including Bill Ackman, were tweeting their impressions of how Rittenhouse presented when he was testifying.
Well, I mean, that was its own separate big moment, right? I mean, I think what the defense had tried to do was in pretrial proceedings try to get a use of force expert to testify as to whether or not this is reasonable. And if they had successfully done so, they probably would not have put Mr. Rittenhouse on the stand. The judge didn't permit that use of force expert. So having a defendant, especially an 18-year-old, take the stand on national TV regarding such, an issue that everyone is focused on is a really big moment and a big risk for the defense. So everyone was definitely thinking about that, looking at that, and trying to analyze what it means. I think he did a good job. But separate from that is the kind of social precedent that this case sets. And I think it emboldens those who believe that if they have open carry rights, that they actually, in my mind, have more discretion to use deadly force than someone who is unarmed. And I think that is really a dangerous precedent.
Yeah, that's a really good point. I just wonder, how does this case help clarify our understanding of how the law defines self-defense and how a jury might interpret it? Or perhaps it doesn't clarify it and it just only muddies it.
I think it just reflects where we are. We have a use of force expert, again, who was if Mr. Rosenbaum in that first incident, who had a plastic bag and aggressing, say, on Mr. Rittenhouse, if that had happened and Mr. Rittenhouse did not have a weapon but was unarmed, would it have been justified for Mr. Rittenhouse to use deadly force against Mr. Rosenbaum? And the answer of the expert was no. And I think that should be a chilling response, because are we considering the possibility that someone with a gun has more discretion to use deadly force than an unarmed person toward another? And that's really what this trial reflects. And I think that should be the point we should be discussing. Do we want to give more rights to use deadly force to someone who is carrying a weapon than if they are unarmed? The answer from the Rittenhouse trial is yes. I think the answer should be no. But this is a debate that we're actually having now.
Yeah, and I mean, if the answer is yes, that it makes you kind of question everything from here on out in terms of what the possibilities are. I wonder as well, Rittenhouse is white, the victims were white, yet race was always present in this trial. It was almost like an undercurrent. How do you think that might have influenced the trial, or maybe it didn't?
I would say race always influences a trial, because if it's a person of color, there's going to be different dynamics that are going to be disfavorable toward a defendant of color. I mean, I've been a criminal defense lawyer for long enough now to see the dynamics are the strategies or the outcome that we expect are going to be affected by a lot of things, right? But race is always one of them. The defense knew this in this case, and the defense would know it if the defendant here had been a person of color. It would change the dynamics. It would change the narrative about who gets to carry weapons. This is one of those ideas that this white kid was a good kid and should be carrying a weapon. But you don't get that in a lot of cases where there's a self-defense instruction and the defendant is a person of color who had a gun. And so our narratives really very much are influenced by race. Even if it's not conscious that we're doing it, it's absolutely, as you say, kind of in the background and certainly shaping the conversation.
I think that's interesting what you said about how the defendant was kind of seen as a good kid. That was kind of like the default setting from the beginning. As you mentioned, the defense did put him on the stand. How do you think he presented? I remember when he testified, a lot of people made the comment that he was crying, he was upset, and there was a lot of empathy for him because of that. And yes, he's young. He's 18 years old now. He was 17 when the incident happened. How do you think he presented overall?
I think he presented really well. I mean, I think when you're thinking about putting a defendant on the stand, you always don't want to do it. That's the default kind of position. But again, this is one of the situations where the defense didn't feel like they had a whole lot of choice in the matter. They needed a response or an interpretation from the defendant's point of view. And so he did amazingly well for an 18-year-old. And the fact of the matter is that he cried or expressed a certain amount of kind of remorse to the jury. And it wasn't maybe not even remorse, right? But being really affected by it is important. You never want a defendant being up there and angry. That's just like the worst kind of case scenario for a defense attorney. And that was not the case with Mr. Rittenhouse. He did not come across as angry. He came across as someone who was genuine, who thought he was doing the right thing. And, you know, one expects a more vigorous cross-examination. I think that was the weakest day for the prosecution. I think the prosecution could have done a better job on cross-examination. I'm not saying it could have made a difference in this case, but I was really surprised about how ineffective the cross-examination was of an 18-year-old kid by a seasoned prosecutor.
I want to go back to that idea that he thought he was doing the right thing. A lot of people questioned why he was there to begin with. He traveled from Illinois to Kenosha on his own to take up arms, essentially to defend businesses, people there. But that part of what he did was not on trial, right? That's not what he was being charged with. It's the action that took place afterwards.
Exactly right. But as you can expect, both sides are going to create the circumstances that led to the incident, and that those circumstances help influence the jury on how they're going to determine whether or not, say, Mr. Rittenhouse was exercising reasonable judgment. And so these background factors do have some kind of purchase in a case like this. Certainly for some people, me included, the fact that a number of open carry, armed white individuals would show up at a protest where over the fact that a black man was shot 7 times in the back by a white police officer, I thought was really disgusting. And, regardless of what you think your right is, you need to take into consideration the surrounding circumstances. So not only was it really, really racially insensitive and causing racial harm by doing that, but then you also escalate a situation that was already escalating under the idea that you're there to ensure order. So while in my mind, you're creating disorder. And so, but obviously that's my view. And there are opposing views who see the actions of these individuals as consistent with law and order and maintaining order. And one can see a history of this too, that there's this idea in the United States, a long kind of history of police departments being white or sheriff departments being white, deputizing other white civilians at various times to create a policing presence. And so this is part of our history in some respects and kind of a modern day reflection of those historical anchors in our society.
Interesting. I hadn't thought about it that way. Your area of expertise is criminal law, Professor Meyn, policing, use of force issues. I know that this is a case that you had talked about in class with your students. What were some of the biggest discussion points in class before this verdict was returned?
Yeah, I mean, some of the bigger discussion points was actually some of the issues that haven't been brought up a whole lot, like as to the fact that he was a juvenile when this happened. I mean, not under the law of Wisconsin, but most of us in the criminal law field and students who are thinking about this understand that brain development for a 17-year-old is really not at a point that we should consider that individual an adult. And so there was a lot of discussion over the fact that on one hand, we're talking about really important self-defense issues that are going to define for adults what self-defense is. And at the same time, you have arguably a kid who's being prosecuted for this. And is it right to prosecute a kid for a crime that could put that child in prison for the rest of his life? Or should this be a juvenile matter and treated completely under a different sort of kind of punitive philosophy? And so that was a big discussion point, one that was not really being discussed nationally, right? But this idea for people who are kind of students who are embedded in kind of criminal justice, like, why are we treating this individual as an adult was a big question. And then allowing what happened by a child to define what the standard is for adults.
Do you think the jury saw it that way? I mean, were they coming up and deliberating their verdict based on the fact that he was 17, even though by the time this trial was taking place, he was 18?
Yeah, and I don't think personally that the age of the person should matter at the time of their being charged. I think it matters when you do something. That's the whole idea that of the person's brain development was at when they did something, right? And so, but I still think, the jury, I imagine, I don't know what happened. No one knows what happened in the jury room, but one could come to the conclusion that a reasonable conclusion that the jury did consider his age. I imagine this would be a different set of considerations for a jury if this is an individual who's 30 years old and 6'2", right? Yeah. I definitely think that his age came into it. That was not explicitly made. I actually think the prosecution made some mistakes here in emphasizing his minor status from just a pure prosecution whine and win from the prosecution side. They emphasized the fact that he played video games and things like that. I thought that was a misstep, right? Why would you emphasize that this is a kid if you want to bring adult charges against this person? But I think it was quite possible for the jury, as you're determining what is reasonable for an individual to feel threatened and thinking about, well, this is a 17-year-old kid. I could reasonably see that come into play in the jury room.
Ion, thank you so much for joining us today. Ion Meyn is professor at University of Wisconsin Law School in Madison. He is a specialist in criminal law, policing, and use of force, commenting on the Rittenhouse verdict, in which Kyle Rittenhouse was cleared of all 5 charges. Thank you so much. This is Bloomberg Quicktake, and we want to turn now to some on-the-ground coverage in Kenosha, Wisconsin. where Bloomberg's Skylar Woodhouse is. She's been outside the courthouse and she joins us by phone. Skylar, good to speak with you. Where were you when the verdict came in?
I was actually in the courtroom. It was quite the scene. I mean, it was dead silent, and when the decision was coming in, the reaction with Kyle's family and the family from the prosecution, they just broke down in tears. Kyle kind of dropped to his knees, and his attorneys were holding him up. There was just a lot of emotions flowing through the courtroom when those decisions were coming in.
How did the jurors look when they announced the verdict?
Some of them had masks on, and I think the masks were kind of hiding some of their facial expressions. I tried speaking with some of the jurors after the decision and once everything kind of died down, and, they were escorted out of the courtroom, and they didn't respond to any comments for myself or other media. And I think the jury was just kind of ready to be done, and you could kind of feel this energy from them that they were ready to go home.
They wanted to move on. They want to end this, close this chapter and move on, which is understandable. They deliberated for about 26 hours. Do we know if that's a long time, not enough time? I mean, what kind of expectations were there in Kenosha for how long this verdict would take?
Yeah, I think people, thought originally, okay, maybe there would be a decision sooner in the week. And then as the week kind of progressed and we came to Friday, there was a lot of conversation of, oh, is this going to spill into next week? Would we be called in on a Saturday? But then, we got that decision today, and it kind of just put everyone to some sort of ease in terms of the waiting game. Mm-hmm. And yeah, so I think no one really knew when, but when we heard it was time, it just, yeah.
Could you hear the reaction outside? We're looking at live pictures right now of a crowd outside the courthouse. There are definitely people there, but it looks fairly calm. I'm sure there's a police presence as well. People have signs up. Did you hear the crowd react in any way?
Yeah, so, the crowd it's not very large, and there will be moments where, the crowd might get a little riled up or it will quiet back down. So it kind of goes back and forth, and it's just kind of a matter of what will happen, or someone might say something that might rile up the other person, and then they'll go back and forth a little bit. But it really has been rather calm out here. I mean, when I was in the courtroom and the decisions came in, you could hear this roar come from outside. I mean, I couldn't tell which side it was on, but you could hear the energy from outside. But there was a medical emergency, and it brought some police in, and, it kind of created a lot of commotion, but the person was taken away by the ambulance, and the police then cleared out. But so far, things are pretty calm.
And are you inside the courtroom right now, or are you outside?
No, I'm outside. I've been outside. I'm talking to just, different people, trying to gather their reactions and what they're thinking. And some people have said that this is kind of setting the tone for, the future and how things might be handled going forward. Some people have said that they are rather surprised when they heard the decision coming in. So I think it's a lot of mixed emotions right now as people still try and process the verdict.
Absolutely. The guest we were just speaking with, Professor Meyn of University of Wisconsin Law School in Madison, was saying that the verdict really shows how it depends on where you are and who you are and how you interpret self-defense. The jury was given wide latitude for what it means to defend yourself. What do we know about the protesters who are out there? Are they people from Kenosha, or are they people who traveled to Kenosha from elsewhere in Wisconsin or outside of Wisconsin, for that matter, to protest and to make clear their views?
Yeah, so it's a mix. I spoke with someone who actually came from Kyle's hometown in Illinois, but then you have people from Wisconsin who are coming. People are really from all over. I mean, I've spoken with people who are from Rhode Island. So, people, I think, are just kind of they're trickling in. I spoke with one man who actually used to live in Kenosha and said he moved out of the city when all of the protests and riots were happening in summer of 2020. So he's now here today to kind of just see how things are going. But it's a mix of people, and people are coming, people are driving by, kind of doing a little drive-by, taking a peek at, what's going on. But yeah, so people are coming in from all over, and they're just really here to see what is happening.
What's the mood like in Kenosha overall? I mean, were people just anticipating this verdict and looking forward to there being some kind of resolution, no matter what it was, or were they really animated in terms of what an outcome that they were invested in?
You know, I think a lot of people, I think when you talk about the people of Kenosha, I think a lot of them were kind of ready for this to be done. I've spoken to people who talked about the media presence and kind of the attention that it has brought to their hometown. So I think a lot of people in Kenosha were ready for this to be over. And now that it is, I think a lot of people are just ready to go back to their daily lives.
Absolutely. Well, you've been a trooper, Skylar, covering this for us. I'm just curious, what angle are you looking to write about next? You're a reporter for Bloomberg News. You've been covering the developments. You've been looking at what Kenosha has been doing to prepare for potential unrest in the wake of the verdict. How are you reporting on this?
I think going forward, I'm looking at the reaction from people and how they're feeling. Are they sad? Are they happy? Like, I'm trying to speak with as many people on both sides of the aisle to kind of get an understanding of where their head's at. But also, I think it will be really interesting to see how this case sets the tone for the rest of the country when dealing with self-defense cases. So that'll be something to watch going forward.
Absolutely. Skylar Woodhouse, thank you so much. Bloomberg News reporter Skylar Woodhouse joining us from outside the courthouse in Kenosha, Wisconsin, where Kyle Rittenhouse, 18 years old, was cleared of all 5 charges. This was after about 26 hours of deliberation by the jury. This is Bloomberg Quicktake. I'm Scarlett Fu.